Hey everyone, welcome to another episode of The Remote Real Estate Investor. I'm Michael Albaum, and today with me I have Kellie Chrisman, who's returning on the podcast with me. Kellie is an attorney extraordinaire, and she's going to be talking to us about all of the things we as real estate investors need to be aware of when it comes to protecting our estate. So let's get into it. Before we get into the episode, would definitely encourage everyone listening to go check out the Roofstock Academy at roofstockacademy.com. It is a one-stop shop education platform, comes with over 50 hours of on-demand lectures, one-on-one coaching, access to private Slack forums in our community, as well as a bunch of other financial benefits, depending on which program you opt to enroll in. So come check us out, roofstockacademy.com. Look forward to seeing you in there. Kellie Chrisman, welcome back to the show. It is always a pleasure to have you on.
Awesome. Thanks for having me.
No, it's totally my pleasure. I'm super excited. You are an attorney, an amazing person, a mother, a rock star. For anyone who hasn't heard your prior episodes, give us a quick and dirty who you are and what it is you're doing.
Oh, this morning. My name is Kellie Chrisman. I'm an attorney. I practice law in California, and I practice California law for other people throughout the United States. I grew up in Chico, which is a Northern California town, Sierra Nevada beer, Chico State, things like that. And then went to college at UCLA, law school at Loyola. And then my husband and I say we got stuck in LA for about 10 years. But we loved it. We had so much fun, and then moved back to the Sacramento area to be close to family and really close to the mountains. We can get to Tahoe in an hour and a half. We can get to San Francisco in an hour and a half. It's awesome. So that's where I'm based now and practice estate planning, business for setting up business entity formation and strategy for smaller investors and real estate clients. And if I can't help somebody, I like to send them where I would trust. So yeah.
Love
it. Me.
And I'm so glad you mentioned estate planning, since that's the topic that I really want to focus on today. So in full disclosure, you are my attorney. You've helped me so much with estate planning and entity formation and just getting all my ducks in a row. So I want everyone to know how amazing you are. And I can personally attest to that.
Yeah, you can say it. I can't. I can't.
That's right.
You're my client, but I appreciate it.
Absolutely. So let's talk about what investors, specifically real estate investors, need to know when it comes to estate planning. What are some things that people should be aware of? What are some things they should be doing? What are some things that they should be thinking about kind of long term?
Yeah, I think that for me as an attorney in this area of law, because I do before people pass away, the planning part, and then I do when people don't plan anything. So I've seen both sides, and I've seen the worst of both sides. But it's not necessarily just investors. It's anyone over 18. Then when you add on, if you own property in California at all, we'll get into the dirty details, I'm sure. Then really are needing a trust, powers of attorney. If something happens to you while you're alive, who's managing your investments? Who's making sure, tenants are paying? Who's making sure, you're in the middle of a transaction that it can close? All of that type of stuff is stuff you can accomplish through an estate plan. And I think it becomes this big giant thing a lot of people don't know anything about. And a lot of attorneys try to make very complicated, but it doesn't have to be.
Okay. So it sounds like just having a will from LegalZoom maybe isn't going to cut it.
I mean, it'll get you somewhere. I was just
maybe not where we want to go.
LegalZoom is great, and so I think that this is one of those areas where I actually had a conversation with a client yesterday where she was very surprised by the cost, and I told her, there's always going to be someone cheaper. There's always going to be someone more expensive. You can go to Costco and buy the wills drafting program, or go to LegalZoom and buy a will. And it will do some things. It'll avoid, maybe getting your property where you don't want it. You can get your property where you want it. But there's a lot of little nuances in this area where I think if you do it right the first time, you don't have to pay for it again. It's an investment in your future, and it's a gift to your family down the road. So it's interesting.
Needless to say. So talk to us about what a trust is, how does it get set up, like what should people be thinking about in terms of cost, or like who even needs one as opposed to just a will?
Yeah. So the difference between a trust and a will, and I think the big thing in this area is probate. In probate, people get very scared, and it's simply the court monitored administration of an estate. That's all it is. So you can pay, go to Beverly Hills, pay $10,000 for a will, or buy your Costco will drafting program and pay $40 for your will, and you're both going to end up in probate. The scary thing about probate, it's public. So if you want to know what was in a celebrity's estate that had a will, you can go and look it up, see where it went. They publish about it. And it takes about a year. I say a year. I used to say a year. Now it's about a year and a half, with the way that COVID has affected the court system. And it's expensive. So the attorney ends up taking about 2 to 3% of the estate. The fees are set by law. And then the administrator or executor, whoever does it, takes 2 to 3%. Then everything is distributed. Versus a trust is when you have enough that you need a trust, which is in California, $166,000, whether you have a mortgage or not. A trust avoids the whole process. It says, here's who I trust to administer my estate, and here's where I want it to go. The court's not involved. That's the goal, and that's the difference between having a trust you've done yourself, or a trust that's been done completely. And having it done and tailored to you, is that the trust has been created correctly, it's funded correctly, and it just functions seamlessly down the road for you. So the will is great, and it says where your property goes, but it's probated, and the trust is the same thing, avoiding the probate process.
Got it. And so why does a will exist versus a trust? Like, it seems like a trust is the obvious choice for anyone that has more than 166,000 in asset or value. I
think so many levels to that answer. I mean, the will is something that has been adopted from common law, something that's been based on what was done in the UK back in the day, which is where a lot of our laws are from. And at a basic level, not everybody needs a trust. So if you don't own over 166,000 in assets, so you don't own, really in California, I just assume if you own a house, you're over that. Right. In every state's a little bit different. I've noticed in some states, because I know not everybody's California, right. Some states that's as low as like 45,000. So it's very state to state. But it's there because it's easy. And so if you don't have enough assets to maybe make the trouble of a trust worth it, then the will is there and allows you to say where you want your things to go. So it avoids what the basic.
Okay.
The other thing is a will's a lot easier to create. You can handwrite a will, as long as it's signed and dated, which I've told some of my friends, they're going on vacation, and I'm like, at least handwrite it out if you don't want.
Do it on the airplane, on the napkin.
Yeah, you can do it on a napkin. You can do it. People have done it, dying with a crayon on a wall. That's a valid will.
Wow.
At that core level, it's just easier. You don't need a notary. You need witnesses. So it allows you to do things. If you have kids, that's where we do guardianship. So wills do all sorts of things. And then to add a layer of attorney complexity, if you have a trust, you're also going to have a will, which actually ends up making sense, but it doesn't do as much.
Okay, got it. And so, for all of our listeners that are not California based, is what we're talking about at a very high level universal, in the sense of, if I have a will, I'm going to probate. If I have a trust, I'm not. Is that national?
Pretty universal.
Okay.
Pretty universal. And you can pick, you don't necessarily have to have a trust from your state. Obviously, an attorney in your state's going to know the ins and outs of the probate law. But if I have a client that I set their trust up and they're in California and they move to Texas or New York, that trust is still valid and they can continue to use it. And a lot of times I have clients that are not in state and they elect to use a California trust, and we work together and I can fund and do everything the same way. So this is something that these these documents that comprise an estate plan are pretty universal.
Okay, cool. And it's funny because we so often hear that California law is like the worst for real estate investors or investors in general. So why would someone elect to use a California trust? I guess specifically, like what are the provisions in that make it attractive as opposed to any other state's trust?
I think that it's not necessarily the law itself in this area is pretty similar. It's not like business law. Business law is pretty unique. If you're talking about LLC formation in, Nevada, Delaware versus California,
Right.
like it's a hot topic. But in this area, it's kind of not. The exciting parts of this law area of law come from really the family dynamic. But there's not much difference. So a lot of times people will choose California law because they have an attorney that they trust that's in California, or it's simply where they were living or whatever it might be.
Okay, cool. And so I live in California now. I invest almost exclusively out of state. And I think a lot of our listeners are in similar situations. Should they be using a trust in the state in which they invest, or should they be getting a trust in which the state they live, or does it not even matter?
Oh, I have to use my typical lawyer phrase. It depends. It doesn't really matter. What matters is that whatever trust you choose, you fund it. When you get assets later, you add those assets into your trust, because you can have the best trust in the world. And if your assets aren't in it, you're going to probate. And
so I could have a trust and still go to probate.
You can. And that's why I say I fix a lot of LegalZoom trust, because people create this fabulous trust and hey, it's super simple. I've got, 2 kids, it's going to them equally. And they don't fund it, or they don't maintain it, or their kids are underage. There's so many different considerations. Their kids are underage and now they're getting a check at 18. So if you don't fund your trust, you don't add the title of your property. So you deed your property into the name of your trust, you update your bank accounts. An attorney will work with you to say this asset should be in the name of the trust, this one's okay out, things like that. Then you go to probate. And that's where you have what's called a pour over will. If you have a trust, your will says everything I have that's not in my trust goes to my trust. It pours over into the trust pot and the trust does the work. But it's still probate. So funding your trust is extremely important. And in California, we have a couple of tricks to avoid that process. So we avoid probate at all costs. But it can be avoided just by doing it right the first time.
Yeah. Okay. And when you say fund the trust, I mean, it just sounds expensive. Let's say your listener has 5 properties. This is just the first time they're hearing about, maybe thinking about that they should have a trust or set up a trust. What is involved with that listener for a couple of properties that they have that are titled maybe in their personal name or to the name of an LLC?
Yeah. So to fund a trust, there's a couple of, I always say there's like good, better, and best. Good is that you list it in your schedule of assets. So there should be a page to your trust. Usually it's the last page, and it should list everything you intend to be part of your estate or your trust. And your intent is a lot of the law. It gives me my defense down the road. Hey, he intended this to be in his trust, but they took it out to refinance. So therefore give it back to the trust.
Yeah.
So you list it on your schedule of assets. Better is it's titled correctly. So primary residence is titled in the name of the trust. It's in the Kellie Chrisman, trustee of the Kellie Chrisman Trust. That's what puts it in the trust. LLC, if the property is owned by the LLC, we kind of trace up, right? So we have the property is owned by the LLC, then we put the LLC into the trust. And so then when we trace down, the ownership is still in the trust. So we don't need to change necessarily the deed to LLC property. So that's better. So good is schedule of assets. Better is titled correctly. And then best is both. If I see both of those things, there's no argument. Hey, he didn't want that to be part of the trust. It's like, well, he clearly did.
Yeah. Yeah.
And bank accounts can be the same thing. So you can either make the trust the owner of the account or the beneficiary. So funding doesn't have to be scary. And I think the signs of a good attorney that's going to help you with this is they're going to give you instructions. They're not just going to hand you the trust and say, all right, thanks for the money. They're going to say, here's the next steps. Here's what to do. Here's what to watch out for. Here's the support on the back end that when you buy a property 5 years down the line and you're like, what do? I don't remember. You can call their office and they're there to support you.
Okay, fantastic. And if someone is looking for an attorney, maybe they're just getting started with their real estate investing and haven't had a need for one in the past, what are some questions that they can use as like screening questions or red flags to look out for as they're trying to reach out to an estate planning attorney? If they're going to use someone other than you, which I don't know why anyone would do, but to each their own.
Yeah, well, and I like to offer people, I mean, when I talk to clients, I see if they're interviewing people, I say, here's what to look for, right? You want somebody that you trust. You can, I think referrals from friends are great. If you're Googling, try and look for Google reviews, or there's a website called Avvo, AVVO. It's like the Yelp for attorneys. How exciting. But they'll kind of narrow it down in your area. Look for great reviews on that. But things to look out for are, what are they including? Are they doing the funding for you? Are they doing more than just, the bare minimum? And then what are they charging down the road? Right. So I see a lot of attorneys charge a yearly maintenance fee. That's great for the attorney. There is no reason you need to do that. And I think if you have an estate plan, you've never had to do anything to it. There's no maintenance. I don't do anything as your lawyer. I have a PDF copy here, and, if you need help, I'm here. So watch out for those yearly maintenance fees. You don't need them. Watch out for what's included. So you want to, at least in an estate plan, a typical estate plan is a trust, a certification of your trust, the funding of your trust. Then you want a will, powers of attorney for finance, and a healthcare directive. Those are kind of the core documents. We say trust, will, power of attorney, healthcare. Okay. The core four. Make sure those are there. And then see what amendments cost down the road. That's the other thing. They might be super cheap, but then you want to change something and it's quite expensive. I like to offer my clients, I do amendments for free for a year, because I have major buyer's remorse. Like if I make a decision, I'm always like, we have to. So, and they're pretty simple to change. So that's kind of, and you want that support. You want to be able to, oh my gosh, I'm closing tomorrow and they need a copy of my certification of trust. I'm on vacation or I don't know where to find it. My clients will shoot me an email or give me a call and I just, fire it over to title or whatever they might need. So what you're getting for the money, I think, is huge.
Okay. And is there a ballpark figure that people should have in their mind as they go to an attorney to get this thing? Because I know you mentioned, the Beverly Hills $10,000 will versus the Costco $40. There's a big range there.
Yeah, it should be in the middle of that. It depends. So generally, and I think that it's going to depend by state, right? But what I am seeing is pretty market is about that $3,000 mark for a married couple. I guess one of the other key things you're going to look for is most attorneys do this on a flat fee basis. It's not hourly. Okay. Because they'll make money. It's a standard process, and usually we can estimate how many hours it's going to be. And then we win some and we lose some, right? Like some clients I end up spending way longer with and make less, and some, it's pretty easy and standard, but it's a lot of paperwork. So that flat fee would be a structure I would look for and that I would lean towards if I was paying somebody or telling family. But every stage is different. So a will is cheaper. If you're a single person, having an estate plan for yourself should be about $1,500, $2,000. And then I look for, if you want to have a trust and your wife wants to have a trust, look for discounts. I mean, an attorney is going to have to do far less work if they know you and they know your wife than so there should be some kind of a benefit there as well.
That's great to know. And then from a lending perspective, if someone is going to buy a property, they're going to get the loan in their personal name, but they want to take title in the trust. I mean, are lenders open to that, or do they need to close in their personal name and then quit claim deed it over into the trust? How does that work?
every lender is different. So it's more and more common for trusts to be there. And I think that lenders get the benefit if you're to pass away. It being in your trust is a huge benefit to them because they're able to follow the trust. So the lender should let you close in the name of the trust. Super easy. If they don't, or if it's some huge hassle, because sometimes, either lender or title is not familiar or comfortable, it's very easy. We end up just doing a trust transfer deed after we close. So a lot of times a client will say, okay, Kelly, it's closed. And then it's a 1-page document that you have to have signed in front of a notary. Some states have more expensive transfer fees or transfer tax that you'll have to pay. So that's a consideration to watch out for. And those can be pretty significant, like $500 or $600. So in those states, it might be more advantageous to close in the name of your trust, but a simple process if you forget or if there's a property.
Okay, awesome. What else should investors need to be aware of when it comes to planning their estate?
I think managing who you trust, who's going to take over, who's going to get your property if you're gone. I think that a lot of the law assumes that an adult is 18 and over. So if you have kids and they are under 18, or they're not responsible and over 18, or you just don't want them to get a large sum of money, a trust should be able to contemplate all sorts of things. I see a lot of clients, hey, I love my kids, but I don't want them to get a lot of money. I want them to, work for it. So everything is held for the kids' benefit, education, whatever it might be, but they're not getting money until 25 or 30. The other thing I often see clients worry about is, who's going to be in charge? If I am incapacitated, if I get in a car accident, having those people that you trust. And then if that person's not there, then who? I always tell clients in my intakes, I'm like, I'm going to come up with the worst scenarios where every person you tell me isn't available and ask you for someone else. So
yeah,
watching out for that stuff.
Okay. Love it. Can you tell us like a gooey horror story of when something went really wrong?
So many. I mean, even like amongst my lawyer friends, everyone's kind of like, oh, you do that area of law? Like, is it boring? It is fascinating. Because families are fascinating.
Totally. Family dynamics. Yeah, for sure.
Yeah. So one of the reasons to have a pour over well, I would say, there was a situation where somebody won at a casino. Very exciting, won a significant amount of money, went out and bought a motorcycle. Didn't put the motorcycle in the name of the trust, which is fine, but didn't put the money anywhere. They, it was just in a bank account. It was coming their way, crashed their motorcycle and died. Now we have this huge amount of money out there that's not in the name of the trust. So the goal is to pull it in and probate it. So we don't have to probate it. So we have stuff like that happen.
Oh my gosh.
I've worked on cases where, the parents have an estate plan that's been in place for 25 years, and then dad has dementia and suddenly has an amendment like a month before he dies that leaves everything to one kid. And that's the kid that took him to, the attorney.
Oh my gosh.
There's so many nightmare scenarios. That stuff we can get overturned. But I mean, all of these have solutions, right?
Yeah.
If you already have it in place. And then families just fight. I mean, I think especially if you have a family that's going to, your kids don't get along, or there's that one person. I always tell people every family has something or someone. And if you don't know who that is or what that is, if it's the right client, I'll say, you need to look at yourself. Like what's going on? Because the estate plan can take that into consideration. I had a client that had a DeLorean and 4 boys, and she said, sell it. And I said, okay, you don't want to, we can come up with solutions. Do you want to have them flip a coin? Do you want to have them draw straws? And she said, no, whoever wins, the other 3 will hate them. And I said, okay, so it has to be sold. And then I was thinking, and to myself, I'm like, well, if it was me, I would have my buddy buy it, right? Like, and then I get the
buy it.
DeLorean.
Yeah.
So it had to be sold like out of state to a third, like a dealer or somebody. Like it was so detailed, like pages
Oh my
about this
gosh.
DeLorean. This is one of those situations where I lost on the flat fee, right? Because I'm drafting about a car.
Right.
But it was fascinating because she goes, I know that's going to ruin my family and I want it sold. So we could do that.
Wow.
It's crazy.
That's pretty impressive.
Yeah.
Okay, cool. Well, Kellie, I want to make sure that we are very respectful of your time. But before we let you out of here, you said something, and I just want to kind of come back and double click on it about in California, if you own $166,000 in assets, then you're going to probate unless you have this trust. And you said that even if there's a mortgage on the property, so let's say I own a property, it's worth $200K, I've got a $100K mortgage on it, my net value or my net worth is only $100,000. So do I fall into that bucket? Where do I land?
Yeah. So I think, yes, you do. So yeah, I start thinking about all these other considerations, right? So the way that probate law works is they look at the value of the property, not the equity in the property, the value of the property, because they see a significant asset that somebody could sell out from under the mortgage company, which is hard to do anymore, but and run away with. And so they look at the value of the property itself, and then the equity down the road in the probate in terms of what everybody's paid off of and what is distributed is taken into consideration at that point. So I have clients that will say, well, I don't really want to pay for the trust. I just want to pay for the will. Because I'm going to put beneficiaries on all my accounts and my property. I'm just going to put joint tenancy. All of that works if everything goes perfectly according to plan, right? So,
which it always does.
It always goes according to plan. You know, parents always outlive their kids. They live till they're 90. The kids are responsible, never get divorced. You know, I never see anything else happen. The problem is when it doesn't work. The last thing your spouse or your kid is going to want to do when you pass away is to see a lawyer, which unfortunately they usually need to do. But that property then, if joint tenancy, goes to one person, and now it's just one person that owns it, and it's not in a trust. So it's, you know, your husband dies and now the wife owns it. And the wife isn't going to, you know, she's grieving. She's doing all of these things and isn't going to think about it. And then when the wife dies, it's probated. Same thing with kind of beneficiaries on accounts are, you know, if I leave it to my husband, he passes away. Now, where does it go? That money can go into probate. So that's where we get IRAs, 401ks, things like that can end up in probate. So people will list their kids next. I'm avoiding it. I still am not over that 166,000. I have a contingent beneficiary. My question is then, what ages are your kids getting it? What is, you know, now we're letting that Fidelity or whatever company, whatever bank it might be, come up with where it goes. If one of your kids is in the car with you and dies with you and your husband, now where's their share going? Is it going to your grandkids? Is it going to the other kid? And so by having a trust, you list the trust as the contingent beneficiary. It goes into the trust and the trust does all the work. So if the worst happens, a good lawyer has already contemplated if a kid dies before you, what ages, all of these things, and you avoid the whole mess. But yeah, if you own a house in California, estate plan, if you or trust, or if you own significant assets, significant amount of stock, things like that, beneficiary accounts, yeah, you can technically, or pay on death, POD, you can avoid it, but it scares me. I make a lot of money off of people that do that because they pass away, and I would rather probate. I make a lot more money probating for clients than I do doing estate plans, but that's not the goal. That's not why I do this.
Yeah. I love it. I love it. Super, super helpful, Kellie. For people that want to learn more, reach out to you for your services, just chat with you because you're a cool, interesting person. What's the best way for them to do so?
So I'm great with email. My website is just taylorchristmanlaw.com, TAYLOR. Chrisman is like a Chrisman man stuck together, CHRASMAN, law.com. My email is just Kellie at Taylor Chrisman Law. Avo, I'm on there. or my phone number, you can always reach out. I've got someone that answers the phone all the time, 916-292-8646. But yeah, whatever people have questions on, I'm always more than happy to help. I guess you should look for a free consultation, because I'm always happy to talk to people. And if I'm not the right fit, or you want to find somebody in in your state or whatever it might be, I like to help connect people where it might be. I think if you put that good karma out there, it helps.
Amazing. Well, Kellie, thank you so much again. This is super insightful as always, and I'm sure we'll be chatting soon.
Yeah, sounds good. Thanks, guys.
You got to take care. All right, everyone, that was our episode. A big thank you to Kellie for coming on as always and sharing some wonderful wisdom and really great insights. As always, if you enjoyed the episode, feel free to leave us a rating or a review wherever it is you get your podcasts, and we look forward to seeing you in the next one. Happy investing.